Welcome to Limits Exhausted, Texas's Personal Injury Litigation Podcast.
Welcome back to Limits Exhausted, Texas Injury Litigation Podcast. I'm Shameika Rhymes, and today we're joined by attorney Kiernan McAlpine, founder of McAlpine Law Firm and a board-certified specialist in personal injury trial law by the Texas Board of Legal Specialization. Kiernan has tried more than 40 cases to verdict and is frequently brought in by other attorneys to handle complex, high-exposure litigation involving 18-wheelers, catastrophic injuries, and wrongful death. But today, we're taking a step back from the technical side of litigation and focusing on something just as important: how to actually build a career in this profession. We'll be talking about what matters early on, what young lawyers tend to get wrong, and the lessons that only comes from experience in the courtroom. Welcome, Kiernan.
Hey, thanks for having me, Shameika.
Thank you for joining. I'm excited about this, talking about career advice. Now, when you look at young lawyers starting out, where do you think they're focusing too much and not enough?
I could talk so much about this question, and my career got off to a little bit of an unusual start in that I entered University of Texas Law School with 100% confidence and conviction that I was going to be an excellent trial attorney. So it's not something that I've ever doubted in myself. But when I graduated from law school in 2008, I graduated right into the Great Recession, and it was very difficult to find jobs. So a lot of the jobs that I wanted to get around that time were jobs that required experience, and I was a brand new attorney. I didn't have any experience. I didn't have a lot of tools to gain experience without getting one of the jobs that needed me to have experience in order to get it. So I started my own solo practice right out of the gate when I was a brand new attorney. And I did that for a number of years. And what I realized very early on, and all of my, guidance and advice today is going to be in the context of somebody who's providing advice or somebody who wants to be a trial attorney, not necessarily like a different type of attorney. But if you want to be a trial attorney, what I would say is that the most important thing when you're early on in your career is going to be getting experience. Okay. I think a lot of young lawyers focus on like the prestige of a law firm, where they want to work for a firm that's going to give them a lot of cachet in terms of name recognition. And there's also a tendency to gravitate towards environments that are highly structured, environments that pay very well at a very baseline, and also firms that will be heavily supervised. It's a very safe and low risk environment to work in at the beginning of your career, but those will often not be the firms where you will be getting a lot of experience early, which the best teacher in trial work is experience and making mistakes in a controlled environment. So your skills developed under pressure are going to be the ones that are the most valuable to you. Those are the career lessons you're going to learn from the most. So I'd say that there's a tendency for lawyers to focus too much on compensation and prestige of the law firm and not enough on like setting themselves up to grow into the type of lawyer that they want to be.
What does it actually mean to be valuable as a young litigation attorney early on?
So this is a really interesting topic to me, because what will make you the most valuable as a young attorney is not necessarily going to be fully aligned with what your career goals are. Like, for example, if you're trying to become a trial attorney, the most important skill that you can develop arguably is going to be taking a good deposition. And, trial skills, like trial advocacy skills. Those are things that your employer, when you're early on in your career, is not necessarily going to be hiring you to do those things. The most important thing to be valuable as a young lawyer is to become technically proficient, to become competent, knowing the rules of procedure, knowing the rules of evidence, knowing how to do discovery, knowing how to, designate experts, knowing how to respond to discovery, knowing how, noticing depositions timely and properly, like knowing the rules of evidence. Like those are the things that are going to be more valuable to your employer, because a lot of the high level legal work that the owner of the firm or the lead trial lawyer is going to be doing themselves, that's the experience that you want to get. But what's going to make you valuable to your employer is just being a very solid, lawyer who can handle detailed work and to know the rules and to be, timely and competent at the sort of basic day-to-day stuff that you're going to be doing as a litigation attorney.
One of the things we hear a lot about is mentorship, and you hear about it in all kinds of careers. So, how important is that really when we're talking about, young attorneys, and what do people misunderstand about it?
So I am very fortunate in that I've had several people throughout my career that have been very influential to me in my thinking about my career and my thinking about practicing law and how I do what I do. And I think that mentorship is a real privilege and a real honor, but it's also something that lawyers shouldn't expect or shouldn't be counting on or relying on to gain the experience and the skills that they want to get. So, one thing that I think is very important for young lawyers to remember is that any lawyer that's taking their time to mentor you in a hands-on way, that is time that they can't spend working on their own docket. If it's the owner of a firm, that's time that the owner of the firm can't spend operating their business and working on their business. It's time away from somebody else's work and in business that they need to be spending their time on. So whatever that you get from another lawyer who's more experienced than you, who knows more than you, that's a real gift. And I mean, one thing that is true for me, and I mean, this could be a fault, it could be a character flaw, who knows? But the fact is that for me, I'm the kind of person where I'm pretty reluctant to ask for help. I'm the kind of lawyer where, if I can find out the answer on my own, I want to find out the answer on my own. If I can use my own resources to get to the bottom of something, I'm going to do that. And I'm typically only going to approach somebody else and ask for guidance if I've already got sort of a theory about what the answer is anyway. I don't like walking up to somebody with my hand out saying, hey, can you teach me how to do something? So I have a tendency to rely on my own resources. And so mentorship isn't something that I got a lot of early on in my career. Later on, I have had multiple opportunities to learn a lot from other lawyers, but it's one of those things where, yes, if you can get mentorship, you absolutely want it. And if a lawyer is willing to donate their valuable time to cultivating you and growing your skills as a lawyer, then you should absolutely take them up on that. But it's one of those things where your skills, you need to take ownership of those and you need to do everything that you can to develop those skills. Like I have spent tens of thousands of dollars of my own money and tons of time on my own accord to go to CLEs, to go to trial skills workshops, reading books about how trial advocacy, familiarizing myself with all the cutting edge advocacy literature that's out there. And I did that on my own because those were skills that I wanted to develop. And I wasn't comfortable uh, expecting somebody else to provide that for me. And I also felt like it was something that I needed to take into my own hands if I really wanted to get that for myself. So it's one of those things where I think that mentorship is fantastic, but it's also limited in that, others are only going to do so much for you. And whatever areas you want to grow and develop in as a lawyer, you need to take as much initiative as you can for yourself to build that.
I think that's great advice. If someone wants job security early on in their career, what's the most reliable skill that they can develop?
Okay, absolutely. So I would say if you want to be a trial attorney, the most direct way to get job security and get experience that you want is legal writing, like brief writing. All right. So a lot of law firm owners and senior trial attorneys are going to want to delegate legal writing to a more junior attorney or to a writing specialist. And frankly, a lot of trial lawyers aren't very good writers. You don't need to be a good legal writer. Excuse me, you don't need to be you don't need to be a good legal writer to be a good trial lawyer. All right. So the fact is that if you are proficient at writing and you're a good writer and you're doing a lot of legal writing, you will get to work on bigger and more valuable cases, because the bigger the case, the more valuable the case, the more exposure there is, the more damages there are, the more motion practices there are going to be. There's going to be more discovery motions, more motions to exclude experts, more dispositive motions. And that is a fantastic opportunity as a lawyer to cultivate those skills and to get exposure to bigger cases. And when a bigger case is going to go to trial, if you're a junior attorney, if you've done the brief writing, if you've written responses to summary judgment, you've done discovery motions, you've done the responses to motions to exclude expert, and you've proven that you can do that successfully, you're going to be the first choice to go to a trial as a second chair lawyer because you already know the case and they already know that you can do good work. So essentially, not only is it a really good vehicle to get job security because there's always going to be room for somebody who's a good writer to work at a law firm, it's a good way to get more involved in cases that are bigger because those cases are just going to have a greater writing burden than cases that are like smaller or like less where there's less energy behind defending them. So, you don't have to be a great writer to be a great trial lawyer, but if you are a great writer and a great trial lawyer, you are really going to stand out because it's pretty unusual actually for a lawyer to be good at both of those things. So early on in my career, it's one of the things where I got a ton of writing work. I got a ton of assignments where, I have to write a response to summary judgment. I have to write a response to a motion for sanctions. I had to do a lot of writing. And because I kept doing a good job, I kept getting more of that work. So it was something that was vital to my career progression because it got me exposure to bigger cases. And it showed that I could do something that a lot of lawyers can't do or won't do or just don't want to do. And it's something that I think is extremely important. I mean, also I would say depositions. I mean, there is nothing that is more important as a skill for a trial lawyer than taking a good deposition. Taking a good deposition is completely transformative in a case, and it's probably the most important skill that any trial lawyer has. So the thing is with depositions is that the lawyer who's the lead lawyer on the case is going to want to be a lot of times the one to take the big expert depo, to take the corporate representative deposition, right? So you're not going to get as many opportunities to do that as early as you want. But if you can distinguish yourself as a writer, it is a very, very valuable skill that I think will take you a long way.
You're making me want to go to law school because I've got some writing skills, so this sounds right up my alley.
Yeah.
Um, but this goes back to what you were saying earlier about, what it means to be valuable as a young attorney.
Yeah, you're doing the work that other people either don't want to do or have time to do. You've got a big shot trial lawyer you're working for. They're going to be thinking about their opening statement. They're going to be thinking about their big corporate representative depo or their big expert depo, the dispositive motion. They're not going to want to do that. And one of the things about writing that I want to emphasize is that writing takes 100% focus. It is very, very hard to multitask with emails, client communications, delegating work to other people. Those types of things, if you're writing, you're in a bubble. You're not able to multitask very well when you're writing. And I think that's one of the biggest reasons why lawyers who are in a more senior position try to avoid it is because they know that, okay, if I've got to write a response to a motion for summary judgment, that's a 10-hour block that I'm not going to be able to do anything else effectively while I'm working on it. So it's one of those things that tends to be delegated. So it'll be delegated on big cases. I mean, sure, somebody's going to be reviewing it. It's going to be supervised. The responses are not going to get filed unless the senior lawyers looked at them and vetted them and tweaked them and stuff like that. But in the actual laboring or of doing the work is going to oftentimes be something done by somebody that's a little bit like less senior. So if you can do that well, it's a really good way to gain like confidence of the people you're working for, get exposure to bigger cases, and just develop a skill that a lot of people in this space don't have.
Okay. Well, how should a young lawyer think about choosing a job? We mentioned earlier money was one of the things that
hmm
people tend to focus on, but when we look at money versus experience versus opportunity, so what would you say about that?
Yeah, I mean, if you're graduating from law school and you're looking for a job, I mean, you want to be compensated fairly. You want to be making money that's competitive with the market. You don't want to be behind your peers. Like you want a job that pays well. Anybody in any field wants that.
Mhm.
Understandable, right?
Oh yeah.
But I think as a young lawyer, what you need to know is that what matters is what's going to make your work valuable long term. Like if you're working in a highly supervised, secure role where you don't have a lot of responsibility, it could pay very well, but you got to ask yourself in 3 to 5 years, what's the trajectory? Like, am I going to be gaining the skills that are going to make my work a lot more valuable in 3 to 5 years than it is today? as a trial lawyer, like you're not going to wake up one day and be, significantly better than you were the day before. So if you're not accumulating skills, you're not going to be positioning yourself for the long run to do like work that's up to your full potential of what you're capable of. So what I would tell people is that, sure, money, great, obviously, yes, but at least, if not more important, and I mean, I believed early in my career, it was actually more important to find work that was going to give me the experience that I wanted, responsibility, taking depositions, communications with clients, the opportunity to at least second chair the case if it went to trial. Those are the things that I really cared about. So experience I thought was more valuable than money. And I would encourage people who are looking for jobs in, trial space or in the litigation space, to the extent there even is a difference between them. I would say experience is invaluable. So what opportunities will give you more experience, I would not take that lightly. And additionally, long term especially as like a plaintiff attorney, but really as any kind of attorney, your ability to develop business and generate new cases for the firm is going to be one of the things that's going to make the biggest difference in what you're ultimately earning. And it's going to be the thing, if you could choose between a D lawyer who's an A at getting business or an A lawyer who's a D at getting business, I think most people will probably tell you I'd rather have, the A business getter than the A lawyer, because an A business getter can feed other lawyers, whereas, somebody who's a good lawyer but can't get cases is going to be somebody who's essentially, feeding off of a lawyer that's generating the business. So you want to work for a law firm that is giving you an opportunity to develop business, to network and things like that. Like if you're working for a super high volume or just like a very, very busy law firm where, you don't have chances to network because you're trying to get out that third set of discovery, or you're trying to get through your, massive to-do list on a given day where you don't have a chance to develop business, or where you're not being incentivized to develop business, I'd say that, it's every bit as important to develop business to sort of grow your career, because that's what's going to feed you and other lawyers for the long term. So, I mean, working for a firm that's incentivizing you to develop business is extremely important.
Okay. Well, Kiernan, this has been an amazing conversation about career advice. Thank you so much for this.
Of course. Absolutely. Anytime.
Well, that's it for today's episode of Limits Exhausted, Texas Injury Litigation Podcast. To learn more about attorney Kiernan McAlpine and his work at McAlpine Law Firm, visit McAlpineLaw.com. Thanks for listening, and don't forget to like, leave a review, and subscribe to the show so you don't miss the next episode.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.